Hello, friends. I welcome you back to my lecture series on the subject intellectual research methodology and intellectual property rights. As all of you know, that this subject has been introduced by Vishwesvaraya Technological University for MBA Part 1, that is Semester 2. Myself, Dr. Basavaraj S. Kuchimat, dealing with the subject research methodology and intellectual property rights. As a part of the research methodology, we were discussing about the intellectual property rights in the last unit of the subject, that is RM and IPR, that is sixth unit. In that, I have already discussed the six lecture series where what is intellectual property, what are the features and features of the characteristics of the intellectual property rights, and we have seen the different types of property, intellectual property rights. We have also already seen in detail with each one of them. In my previous lecture series, there is lecture series 6, I have discussed in detail what is patent, what are the characteristics of the patents, what are the different types of the patents, and we have already seen the laws relating to patents and how the patent is being protected. Patent right is protected in the Indian context. And today, in the continuation part of this lecture series, that is protection of intellectual property rights, a brief summary of the patent is over. And today we are going to discuss the brief summary about the copyrights and trademarks. Let us understand something about the copyrights as we have discussed in about the patents. Today we are going to discuss what is copyrights, what are the features of the copyrights, and what are the legal rules governing the copyrights, etc. As all of you know, that copyright refers to the legal rights provided by the law. It is provided by the law to the original creators of the work in the field of literature and computer software. In the field of literatures and computer software, certain rights are given to the original author, where he can protect his creations, the literary work, or the creation of the musical work, or the creation of the softwares under the Copyrights Act. So nobody can copy them and use it for commercial purposes. That is how to prohibit that. This Copyright Act has come into existence and is trying to protect the interest of the authors, to protect their creations. The related rights encompasses the author's work in the field of dramas, in the field of sound recordings, films, video recordings, paintings, architectures, etc. What are the things which are covered under the copyright? Copyright is the creation of an author. Author and an inventor are two different people. Inventor is one who invents new product, and if the commercialization of that has to be done, the original owner, that is the inventor, has to permit it, has to come forward it. When it is registered, the original inventor's work is registered in the form of the product which is introduced in the market at the new product. It comes under patent. All the patents are normally are in the form of tangible assets, whereas copyright is the title of the authors or is the creators which are intangible in nature. For example, literary work, the literatures, poems which are what you call created by the authors, the ownership of that is intangible. Music is intangible. Film is intangible. Unless and until the people go through it, they will not able to understand what it is. That is why in such cases, the copyright will come into existence to protect the interest of the authors. Most important types of the copyrights and importance of the copyrights, let us discuss today. What is the most importance of the copyright? Why copyright is most essential? Copyright is creation of public record. Main important point is copyright becomes a public record. Once the public record is created, it is the asset of an author who creates that. Either it may be a publication of a book, publication of a journal article, or it could be a publication of any kinds of poems, literary work, artwork, or even the paintings of the person. Like M.F. Hussein's paintings are recorded, are having a copyrights. The A.R. Rahman's the work like Jai Ho is also copywritten. Nobody can duplicate it or copy it during the lifetime of the creator. That is the creation of the public record. Right to sue for the copyright violation. Anybody who violates that, the copyright can be sued or argued by the original author that his work is being copied, and the person who has copied is considered as a culprit or a person who has committed a mistake and will be punished under the law. In order to protect the rights, punishment is being given under the act. Next important in the act as evidence. The original work acts as an evidence. Anybody who copies that the original work which is published before the copied publications, it can easily be proved and can be what you call as asked for compensation when it is, even if it is not registered also. Copyright is not necessary to be registered. Once the creator has created it, and when it comes to a public record, automatically the original author will have the rights on that. No party can duplicate it. If at all it has to be duplicated other than the commercial purpose, then this work has to be referred. Reference should be given in the copied work or the extension version of that, how the original work has been used, and what the reference of the original work has to be given. That is what the requirement. Anybody uses it for commercial purpose without the knowledge of the original author, then it becomes the violation of the act. So acts as an evidence, recovery of damages. Any person who copies it without the knowledge or without the permission of the original, even if it is done without the permission also, when the original author asks for compensation, then recovery of the damages shall be made out of it. Protection against the import, that is import of copyright. Copyright is protected against import or export. Original authors has to be given permission for that. If the copyright is transferred to third person can export and import the work of the original author. Unless and until the person author's permission, it cannot be done. Types of copyrights, if you look into, I think I have already discussed while discussing the brief summary, brief information about the different types of IPRs. We have seen what are the various types of the copyrights. One is literary work. As you know, the authors who write the poems, books, or any of the collections of the materials, dictionaries, all these are called as literary work. Even the encyclopedia that is created becomes a literary work. Dramatic work, any kind of a drama for which you write the story, you write the dialogues, you write all that kind of things becomes a dramatic works. Even the drama which are played should never be copied by other person without the knowledge of that. Musical work, any kind of a musics that is composed, musics becomes the rights of the music composer. Like Jai Ho is the composition of the A.R. Rahman. He has the right on copyright on that particular unit. Artistic work, any kind of a drawings that is being made. Cinematographic film, what you call as sound recordings and all that becomes the even sound recordings also. As all of you know that Hum Aapke Hai Kaun is the film recording made by Saregama. Without the knowledge of the Saregama, if it is being played anywhere in the public for the commercial purpose, then it is prohibited. For the entertainment purpose, it can be reproduced, it can be sung by anybody, that is not a problem. But if the same recordings are being used for commercial purposes, then those songs cannot be played in the commercial activities unless and until the royalty for the copyright is given to the recording holding authorities. If you see the Copyright Act the Act and its protecting mechanism in India, we could trace out the Copyright Act came into India late before 1957 itself. Immediately after the what you call as after the what do you call as first industrial level revolution, a first industrial policy that is placed in 1956. And when 1956, when the Republic Day is celebrated, when is the Indian Constitution is accepted, immediately after that, copyright came into existence. Copyright is protecting the author's work. It may be a music, it may be a literary work, a dramatic work, or it may be any kinds of what you call as works that are being created are protected under the Indian Copyright Act of 1957. This 1957 Act is enacted on 21st January 1956. Earlier to this, we had a colonial era, that is a British rule. During British rule, this act was passed in the year 1914 in India, and this act got amended in 1958. as per the recent trends after the Republic India, after the India got the freedom. Establishing a comprehensive framework to protect the creative expressions across the nation. The Act governs the protection of literary, dramatic, musical, artistic works, as well as cinematography, films, and sound recordings that we have already seen. What are the things which are covered under the 1957 Copyright Act are the literature works, dramatic works, musical and artistic works, as well as cinematography and sound recording activities and all that. At its core, the Act defines copyright as a bundle of exclusive rights granted to creators, including reproduction, communication to the public, adoption, and translation as a signatory to major international treaties, including the Berne Convention, TRIPS, and the WIPO copyrights and all that. India joined this copyright movement at the international level in 2013. Earlier to that, we had an Act of 1956-7, but in 1913, India joined the international movement, and all that copyrights of the international level was brought into India by amending the 1956 Copyright Act. Importantly, copyright protection in India is automatic upon creation. Very important point of this copyright is, in case of patents, you have to register it. In case of any other kinds of IPR, you have to register. But copyright need not to be registered. It will get automatically registered when the original work is being published. Only the evidence of the original work is necessary to claim for the damages for copying it. But so many a time, whenever the original author transfers his rights to third person, then the person who buys the copyright has to register in his name. That is why transfer of copyrights when it is made. Take an example. If you write a book on principles of management, or if you write the book on the research methodology, as an original author, it cannot be copied. You have exclusive rights of publishing the books. But if at all you want to publish the books through certain publishing house like Himalaya Publications, Chand Publications, Pearson Publications, if they are ready to publish your book, then they will pay a royalty to you. Once they pay your royalty, the copyrights are reserved by the publication authority. That is what Himalaya Publication, Chand Publications will take the right of that. And they will mention the copyrights are reserved by the publisher only. When it is not the writer's authority now, it becomes the publisher authority once it is transferred. So registration is required when the transfer of copyright is being made. Key rules of copyright, if you consider, what are the key rules? The original author is the owner of the key major rule is original author is the owner of the copyright. Anybody who steals that without his knowledge, right, without his permission, it becomes violation of Copyright Act, even if it is not registered also. But if at all it is sold or it is withheld by somebody else, then the transfer of that particular copyright has to be registered. That is what the original. Copyright protection typically lasts for a lifetime of the author plus 60 years. It means that the copyright reserves is for lifetime of the author. If the author is surviving for 70 years till the death of the author, the copyright are reserved in him with him. If he dies, his next ancestors, next heirs can have the authority to continue that. This is what we call as copyright. It means that the total copyright lifetime, if it is not transferred, if it is not sold, it remains with the family of the author till the lifetime of the author plus 60 years for the next. After the expiry of 60 years, when one next generation gets expired, copyright automatically goes off. Copyrights automatically goes off. For example, if you are publishing the original work of the Ramayana written by the what called as Valmiki or the Mahabharata written by Vyas, which are original scripts, you can easily copy that because already several years are went. So there is no problem in copying that. Any such books which are available, Vedas, Upanishads, which are brought into picture, or for example, the Vachanas of Basavanna. If you see Vachanas of Basavanna, if at all you want to quote, publish, or compile and edit, nobody can stop you because the copyright has already expired, because Basavanna is not there. After that 60 years are also over. Like that, certain old literary works, in order to benefit to the society, can be compiled and distributed to people without any copyright problems, because the author doesn't survive, and already after the death of the author 60 years are passed. This is what the law says. Indian copyright allows a fair dealing approach rather than the broad fair use. In USA, it is used as fair use, but we use fair dealing. Fair dealing in the sense, any kind of the copyrights, if you violates for the purpose of benefiting the public without the commercial use, such kind of a copyright violation doesn't become a violation in Indian Act, provided if the reference of the original author is given in any of the publications. You need not require to worry about it. But if at all you are using it for commercial purposes to earn money, it is your bound duty not only referring it, but also taking the permission of the original author for the purpose of doing it. For example, for the research work, if you are making a literature review in PhD or literature review in MBA thesis, you are referring many books, but content of those kind of books, references, journals, if you quote in your research and use those materials for your further research work, it is not violating the Copyright Act, because you need not require to pay to the author, but you can give the reference, because PhD work and all that is for the education purpose, not for the commercial purpose. Provided if you are using such kind of articles or preparations of some things for commercial purposes, then you have to take the permission from the original authors. This is what fair dealing. Fair use in the sense, in US concept, fair use in the sense, if at all using it for government purpose, it's okay. But if it is used by any private, even for public purpose, for research purpose, certain kind of reviews for purpose of drafting a criticism is opposed under the US Act. You have to ask the copyright, the permission from the original author to criticize or to review or to report any for any kind of purposes other than the government publications. This is what we call as fair use, fair dealing and fair use. That is the difference between the Indian Copyright Act and the US Copyright Act. Rules of copyrights, if you consider another part of it, remedies against the copyrights will be, if at all anybody violates the copyrights and the original author claims for the damages goes like this. It is injunction damage, that is not to use it. Injunction means not to use the original work of the original authors. Anybody who violates it accounts for the profit. If at all is earning any profit, then it becomes a criminal offense. And such criminal offense are subject to 3 years imprisonment and up to 2 lakhs penalty. Up to 2 lakhs penalty. And if the same person repeats it again, copying the same thing again, even after the first punishment and administrative remedies, then he is subject to an additional 1 lakh result, that is a reprint, leads to more severe penalties, including minimum imprisonment of 1 year and fine up to 1 lakh will be levied for the person. At any point of time when he continues copying, then he will be under this kind of a problem. Many kind of what you call as news writers, many kind of journal creators are always afraid of this act. If at all they publish without the knowledge of the original author, without taking the consent to publish, if they publish this and the original author claims for the damage that his publication is being published without his knowledge, giving the original evidence proof of it, then they are likely to pay the penalty and should also undergo imprisonment, and is treated as criminal offense. The law also provides for the Copyright Board and Copyright Office to handle disputes and registrations. So let us see the another part of it, the brief summary of trademark, which is most essential to be discussed as the second part of it. As all of you know, the trademark is a symbol or the name or the color or a kind of pieces of drawings which are registered under the Trademark Act. That is, certain products or services are recognized as those of manufactured or provide a specific individual or business enterprise by means of an exclusive sign. That sign is tuned as a trademark. Trademark in the sense for the trading purpose. The products are marked with a certain attractive logos, attractive colors, attractive names. So such things are called as trademarks. And these trademarks are also comes under intellectual property rights, where without the knowledge of the company, you cannot use it. So there should not be duplication of that. As all of you have already seen the various trademarks that are being used in day-to-day life. Like for example, Cadbury chocolate, the Windows, then the LG company, this one, Google, McDonald's, Adidas, Coca-Cola, eBay, Virgin, WWF, Amazon, Starbucks, and Apple, then Twitter. These are all having a specific name. If you see what kind of things you identify here is some of them are in the form of what you call as animals, like WWF is a kind of beer that is exhibited here. The beer style should never be copied. It is not only the beer which is registered, WWF, what is written below that is also registered. So trademark is not that beer. Trademark is beer with the WWF. Anybody who copies can copy that what you call as beer, but cannot copy beer with WWF writing style. This is prohibited. And the colors, like the Microsoft is having a 4 different colors with it: orange, then green, blue, and red, blue, green, blue, and orange colors that is being exhibited. LG, the lighting style on that particular color. Cadbury, the writing style with the color. Then Facebook, writing style with the F, that is color and F. These are all called as registered trademarks. Starbucks, the mermaid with the green color, mermaid with the brown color, and all that. These are all called as various types. In India and in Pakistan, they have green color mermaid, and in some other countries they have a brown color mermaid. In India, brown color mermaid can be copied because it is not registered, but green color cannot be because it represents cafe coffee day. That is how we can sorry, Starbucks, these things. So some are the animals and all that. So these are all copied. Features of the trademark, if you consider uniqueness, the product symbol is always unique in style, either in terms of colors, writing style, or a kind of animals which are registered. Non-descriptive names. The names are normally non-descriptive. They do not have non-descriptions, like Cadbury, just a name. Doesn't describe the chocolate company produced, established in this year, production capacity. No kind of description. Only the customer looking at that will identify it is the product of this nature. Apple, for example, the cut apple style of the Apple mobiles, Apple electronic companies producing the mobiles, laptops, and all that. You identify this is made by Apple. No other company can copy it because it is all patented. Then not a geographical name. No need using, you should not use the geographical name. Like geographical tag will be there, that is registered under the geographical indicators. That is a separate intellectual property right. But any company who registers the trademark should not use the word of the area, place, like Delhi in Belgaum. You cannot what you call as use these words for any kind of registration. For example, Belgaum Kunda is not coming under trademark. Belgaum Kunda is written by anybody who produces the Kunda in Belgaum. But Purohit, the name, which is the name of the family, can be used as a registered trademark. No third party can use that Purohit Kunda. Anybody who produces Kunda can use that Belgaum Kunda, but it should be produced in Belgaum with the ingredients of Belgaum. Then it is called as Belgaum Kunda. That comes under geographic indication. That is also right. Anybody who produces the Kunda in Dharwad or in Bijapur and calls it as a Belgaum Kunda, it is wrong, because it is Kunda produced in not in Belgaum. Kunda is not a what you call as registered trademark or geographical, but Belgaum Kunda is having a registration trademark. Gokak Kardant, for example, production made in Gokak only will have a Gokak Kardant. If I produce in Belgaum and say that is Gokak Kardant, then anybody can claim for the damages as a customer that you are deceiving. It is not produced in Gokak. That is what comes under. It doesn't come under Trademark Act. It comes under specifically geographical indicator, non-descriptive nature and all that. So let us understand the protecting brands. Trademark How the trademark is protected in the Act? The Trademark Act of 1999, passed in the year 1999, protects the trademarks. After the globalization, when India signed the GATT, that is General Agreement on Trade and Tariff, in the Urge round discussions, and become the member of the World Trade Organization, and open up the economy for the direct investment, the immediate act was amended in 1999. Earlier to that, we had earlier act legislation 1940 and 1956. We had the act, but we have bifurcated the Trademark Act than the Patents Act and other acts, and it is separately done under the Indian Trademark Act of 1999. The comprehensive update modernization India's intellectual property framework to is aligned with the discussions made in intellectual property right, that is trade related intellectual property rights, TRIPS, and the Urge rounds and all that. That is what the things are. What are the characteristics of the act? The act is administered by the Controller General of Patents, Designs and Trademarks under the Ministry of Commerce and Industry, providing governmental out, that is oversight and enforcement mechanism. It means that the trademark is being controlled by the Controller General of the Patents Design. Earlier it was there in 1999. We have added the trademark controlling activity to the Controller General, which comes under the Ministry of Commerce and Industry in India. Under this legislation, a mark is defined as a mark capable of geographical representation that distinguishes goods or services. This includes traditional elements like names and logos, but also extends to more distinctive identified shapes, packaging styles, colors, and even sounds. It means that except the geographical tag, you can use any word, any kind of a name, any kind of the shape, size, package, color, and even sounds for the product to identify the names. For example, the jingle sounds which are used in the advertisements by creation of the own creation of the what you call as artistic work done by the organizations, companies using that particular jingle word should never be used by anybody. For example, Thanda matlab Coca-Cola. That is what the Coca-Cola has created that sound, music, and the what you call as dialogue. That is trademark. No other company can use that because it is trademark. Anybody uses it, it violates the trademark law. Trademark registration process, if you consider, there are 5 important steps for registration. First one is trademark registering authority, that is the companies, should comprehensively search to avoid the conflicts with the existing trademarks, that your trademark should not resemble with the existing trademark. You should identify one best trademark. And after identifying the trademark, you should apply for filing it. That is, you have to apply with the controller of trademark authorities in Bangalore, in Chennai, in Delhi, and all that. You have to register for that. When you submit the details specifying the mark class from 45 nice classification categories, there are 45 categories made under the act. You can pertain to any one of these 45 categories. For example, for the product of a marketing nature, for the purpose of society, for the purpose of college, certain names are called as trademarks. Like for example, Vishweshwaraya Technological University with the Vishweshwaraya's logo and with the name writing Modalu Manavu Nagu. So this is what the registered this one application has been filed. Then what happens in the third step? Examination is made by the controller of the trademark, that is the under the Minister of Finance. They will review and try to find it out and publish the notice that this company is going to register with this logo. Any company which is already existing similar to that should what you call as file a complaint to stop it. Nobody if does it response, then that product will get registered. That is including video conferencing since 2016. In some video conferencing are done and it is exhibited in the newspapers and all that. Then it is done. In the fourth step, publication and opposition. Any oppositions and all that will come, the registration will be stopped. The last one is once there is no any objections regarding the trademarks that you have decided, after a specific period of time when all investigations are made by the controlling authorities, your registration act will be made. Okay, friends, then next intellectual property rights, if you consider today, in excluding all the discussions we have made, I will come out with the challenges that are being faced by the intellectual property rights after this discussion. Major challenges that are being faced by the intellectual properties, whether it is patent or whether it is a trademark or whether it is a copyright or whether it is the geographical tag, anything it is, there are certain kinds of challenges that most of the people face in world, not only in India, I'm talking about. The first important problem is balancing innovation incentives with the public access to knowledge. Public are in need of knowledge, but the patents are withheld by some individual, and the individual patents are most essential, intellectual property rights are most essential for the public to use. Then there will be a conflict whether it has to be copied or not to be copied because it is most essential. In such cases, government will intervene into that. For example, I can give you a one cancerous drug which was recently invented by America, that is a ibrutinib for specifically for blood cancer diseases. It extends the lifespan of the sufferer with the leukemia, that is specifically the chronic leukemia, the good medicine, which will prolong at least for 5 to 10 years lifespan for the patient. This, when it is invented, this has become a protocol of what you call as the chemotherapy, oral chemotherapy for most of the people who are suffering for this. When this drug is introduced, it has become widely accepted, but unfortunate part is the drug becomes very costly. Public cannot apply it. Indians especially, it was very difficult. You have to pay lakhs together just for 30 to 40 tablets, which you have to consume for every month. Buying a 1 month life for 33 to 4 lakhs rupees is not affordable for most of the people. Then government intervened and cut short that particular patent rights of the company, requesting them on the social grounds that kindly cut short it. Within next 6 to 7 years, the authority made it public and sold it to the government, and government made it free to all other countries. And because of that, Indians are getting that at the most affordable price in India because patents are big. So this is what balancing becomes very difficult when the innovations are most essential for the public and the original author wanted to charge more for it and the royalties are very heavy, then it becomes very difficult to manage. That is one problem which is being faced in the intellectual property rights. Protecting software and AI generated content is very difficult because these softwares can easily be copied by anybody and may be used anywhere. Because, for example, Microsoft has a legal version of Windows. But how many people really use the Windows Microsoft original version by paying money to the Microsoft? Because it is very costly. There are many people who use it pirated, and pirated are more in market. Everybody has a Windows, but very few of them have got a what you call as a real version, original version of it. That is not there. That is why piracy may lead to one or two because functions may not work, but rest of the things will work nicely. So when most of these things will be uh, affected, that is how the things are done. Traditional knowledge, ಆಮೇಲೆ ಒಂದು ನಿಮಿಷ. Traditional knowledge and generic resources, patent thickness, that is uh, thickets and strategic IP blocking. So traditional knowledge and generic cannot be done. If you start doing that, it becomes very difficult for the next generations to learn it, especially when you publish the records to the research and research article is not made. Some of the historical events may not be available to the public. Enforcement in digital environment is very difficult because digital things are copied very easily. They fastly though goes in the market. So controlling that becomes very difficult. These are the basic challenges. Thank you, friends. Thank you for watching my video. Hope this video will help you for preparation of your examination. I will come back with the other kind of discussions in the next lecture series. Thank you. Thanks for watching the video.